Well, good morning, everyone. I'm Jim Falk, and this is the first time that I've had the pleasure of hosting one of these programs, especially the rule of law. So, gentlemen, welcome to all of you. Thanks for being with us this morning. So, let's
Thank you.
get started. Golly, it's hard to imagine, but it has already been 6, 7 months since Donald Trump was impeached by the House, then quickly acquitted by the U.S. Senate on the charge of causing Capitol insurrection. So let's begin this way. Why don't each of you pick maybe two events, one that helped, say two events in the last, since in the last few months, especially since the Biden administration came in, one that is helping reinstate the rule of law, and the other that threatens it. So, Chuck, let's hear from you first.
All right. Well, I was trying to think a little outside the box. And so my two are first, the successful creation of the January 6th committee in the House, but most importantly, I think the addition of both the representatives Cheney and Kinzinger to make that a bipartisan event. And it's started, I think, quite well with the first day of testimony. The missed opportunity I see is the failure of the Justice Department to take stronger action against the so-called Arizona audit, because it is directly, what happened there is directly contrary to an important US civil rights law. And I think that the Justice Department had a strong case to bring a preliminary injunction or temporary restraining order action to stop that before it got started on the basis of the integrity of ballots and other voting issues.
It's good to see attorneys who pursued the big lie being held accountable. It's terrible to see state legislators enact not just voter suppression statutes, but election subversion statutes. And we'll talk more about that later.
I think on the good side, the fact that members of Congress are willing to be arrested to take direct action to promote voting rights, as was the same with the Texas delegation coming to the Capitol. That's part of American tradition in of MLK and John. On the other hand, when you have people like Tucker Carlson and others extolling illiberal democracy in Hungary and broadcasting from Hungary at a time when we are trying to reestablish our global leadership in a values-based way, that erodes global confidence when they see us speaking against our system of government. And we can talk more about what that means internationally later.
What role does the Department of Justice have on this? But before we get to that, there's been so much back and forth and changes of positions from the senators, particularly with Mitch McConnell. I know we've identified a clip that we'd like to show. Let's see if we can make that happen. And if not, there it goes. So let's see.
As an ordinary citizen, unless the statute of limitations is run, still liable for everything he did while he's in office. Didn't get away with anything yet. We have a criminal justice system in this country. We have civil litigation. And former presidents are not immune from being accountable by either one. I believe the Senate was right not to grab power the Constitution doesn't give us.
Essentially, Mitch took the position that former presidents can't be impeached, but also clearly stated, this is in the hands of the criminal law. And this president has not been let off yet, and he emphasized that. So in that context, I want to say in our first ROL talk in April 2020, we noted the critical and existential difference between a republic and an autocracy, and that's whether everyone is subject to the laws or whether rulers are accepted. US DOJ has the exclusive ability to answer that question. So far, in my view, it has not done well. Now, certainly US DOJ has taken some positive steps to reinstate rule of law principles, but the gorilla in the room is whether Donald Trump will be held accountable for any actions that may have violated federal criminal laws. Now, some say we don't know what US DOJ is doing, although tea leaves suggest active investigation of Trump as a criminal suspect is unlikely. What should already have occurred, in my view, and what we know has not, is the appointment of a special prosecutor. That would be well justified by the fact that the US DOJ as an institution was compromised, seriously compromised in the past administration regarding any criminal investigation of Trump, and is also loaded with material witnesses. I would appoint a special prosecutor with two specific roles. One, determine without further investigation whether criminal charges should be pursued against Donald Trump based on the Mueller investigation, and if so, pursue those charges. Two, investigate whether criminal charges should be pursued against Donald Trump in connection with efforts to overturn the results of the November 2020 presidential election, with particular focus on the Capitol insurrection, and if so, pursue those charges. Now, that special prosecutor need not be a current or even recent US DOJ employee. There are 50 state departments of justice from which to select an impartial and qualified special prosecutor and staff. But the question is whether anyone is or is not above the law. It's a yes or no question, and US DOJ controls the answer.
There is a case to be made that this should go slowly, and that the Garland approach at the present time, which is to look forward and not look back, and with regard to looking back, to refer those matters to the Inspector General. These are particularly matters having to do with DOJ itself, is a position that respects the integrity of the executive branch and of the Department of Justice. Now, at the same time, we know that affiliates or associates in the former administration or of the former president, such as Tom Merrick, who's recently been indicted. Rudy Giuliani is still subject to investigation and potential indictment. And frankly, we don't know, as Rich said, whether or not there are other matters under consideration within the Justice Department or individually among the U.S. attorneys. Plus, we have the investigation in Florida, and we have the investigation in New York, and now we have the Congressional Committee investigating January 6th. I personally think it would be premature to bring criminal charges or to start a criminal inquiry against the former president while Congress is in the process of making that inquiry. So while I understand the desire to hold members of the Trump administration, including the former president himself, criminally liable for what has gone on, I am not personally offended by the fact that it's in a go slow mode at the Department of Justice.
There's a debate that some will say there's different processes, whether it be in Georgia or in New York State concerning the former president, and that it would be preferable not to have the specter of a political prosecution, even if it is not politically motivated, but rooted in law. But from a public perception standpoint, it could be preferable for the DOJ to step back and allow these state processes to go forward. I'm curious what your perspectives might be on that question.
Well, my thought is there are some several things. The book After Trump, which was written back in August of last year, talked about the importance of holding former presidents accountable. Understandable that you don't want to necessarily prosecute presidents in office. That's understandable. But former prosecutors, you have to be able to pursue and do things about. There are federal criminal laws that are at issue, particularly in the Capitol insurrection, that were not implicated, or did not implicate actions that did not implicate state or local laws. They may have, but the federal criminal laws that were involved are particularly important. Only the US DOJ can do that. That After Trump book made the point that if the US DOJ does not work to hold a president accountable, you will have state and local prosecutors in a scattered way going after former presidents. Is that preferable?
And let me just make a note that in South Africa, the former President Zuma has recently been imprisoned, that has sent off a series of riots throughout South Africa by his supporters. Okay. And so I think that it's noteworthy for people that want to look at that, what potentially occurs in other environments, that we do have other countries that have lacked rule of law that are seeking to establish it and are taking such actions as the imprisonment of former presidents. And the South African example is simply something that's happening right now.
Mm-hmm.
Let me switch gears for a minute. I'm holding excerpts from an article that was in the Washington Post magazine on July 19th, and it was an in-depth study of the article about the Attorney General, Merrick Garland. Let me ask each of you to briefly say, do you think he is approaching this in the right way? I think we all agree that he's really leaning on the institution and making some adjustments slowly because of his concern, and I suspect your concern, that the department was politicized in the past administration, and he thinks it's better for it to really just go slowly and let the institution reassert its legitimacy. Rich, you're nodding your head. Why don't you each respond to that in 30 seconds?
Okay. I think a go slow approach when we've had an incredible assault on the rule of law is mistaken. I'm talking about the specific question of whether or not the former president committed criminal acts. And I'm not saying he should be held criminally liable, but investigate in an impartial way. And I would, in that press conference, play the clip from Mitch McConnell that we were intending to play.
Chuck?
I favor the go slow approach. And I think it's really too early to tell. We don't know everything that's going on inside the Justice Department. And it seems to me that there is the possibility of simply repoliticizing the Department of Justice if, in fact, that becomes a primary focus at this point in time.
In my view, it's not a question of go slow or go fast. It's a question of operating in a way that reflects institutional integrity in an open and transparent manner, so that people can have a reinvigorated confidence that we are not behaving politically in the enforcement of our laws, and that we act in all manners to add support to that view. And whether we have a lot of information, for example, from the Mueller report, which you can say advances an inquiry because there has been so much work done in that one area of obstruction of justice, or in other ways that requires further investigation that would take a longer period. I think the key is that we do it in an open, transparent, non-political manner with the goal of reinstilling confidence in the integrity of our process.
Let me bring in one of our viewers, Herb Thomas. And Mr. Thomas asks, is Trump's criminality a mosaic in which one piece, the notes taken by the acting Deputy Attorney General, can fit into Georgia's investigation?
Hmm.
Who would like to take a stab at that?
Well, what strikes me about the notes taken by uh, the acting attorney general's assistant, I think is who, or the deputy to the acting attorney general, is how much it parallels what happened in Ukraine. It's exactly the same thing, where what Trump was saying was, all you have to do is start the investigation against the Bidens, and then I'll take care of the rest. And here he's saying, all you have to do is say, call it corrupt, and I'll take care of the rest. He's looking for some kind of trigger or cover. So I'm not sure that it really is within the same scope as Georgia, but it is strikingly similar in a domestic way to what went on in Ukraine that led to the first impeachment.
I agree. And I think that Herb, you could take that piece of evidence and use it as a Georgia prosecutor. It's evidence. It's nothing. So it isn't a crime that occurred in Georgia and therefore can be prosecuted, but it would be evidence that could be used by the Georgia prosecutor. But this actually confirms two things. That call confirms how many material witnesses there are within the US DOJ, current or former people. It also confirms, when we talk about a Georgia investigation, a New York prosecution, et cetera, that if the US DOJ does not act, then you're going to get these satellite prosecutions occurring.
And so if you would have had the statement of corruption, that could have been evidence justifying the subsequent letter, which could have then collectively been used to try to create the perception or the action on 6 different states that went for Biden to send alternative electors that could have been then used on January 6th to have further contesting of the certification of electors and contest the election itself.
Richard, I want to sort of switch subjects for a minute. You served as a Foreign Service officer, and so many of our viewers and members here are involved with the International Visitor Leadership Program, where they welcome visitors to come for 3 to 4 weeks in the United States to learn best practices, exchange views, and one of the most important topics that they come to discuss and perhaps take back to their countries is how our democracy works. How are we being perceived now? I'm sure you're talking to former State Department peers and people who are maybe still active. How are they defending our democracy right now and explaining it?
So let me begin by saying there was a Pew study that came out, I believe, in June of this year, that talked about foreign perceptions of the U.S. And there was one broad conclusion that was given a lot of airtime, but it really didn't tell the full story. And the conclusion that people looked at was the fact that at the end of the Trump administration, the U.S. got basically, or I should say, President Trump was given a 17% approval rating by foreign audiences, and that quickly changed to a 75% approval of President Biden within upon him taking office. And this translated to the general perception of how foreign audiences looked at the US. And so this kind of question that President Biden would say is, the US is back. And does that mean that the status quo ante has been returned? And a lot of people would just say this is evidence of that. But I think if you want to go a little bit deeper into the public perception by foreign audiences of the US, it gets a lot more complicated. And to that extent, if you look at the percentage of people who say that their opinion on democracy in the US and is it working? Well, 57% of the people poll said it used to be a good example, but it's not in the recent polls, with only 17% saying that US democracy is a good model and 23% saying that it's no longer a good model. If we then go and say, is the US political system working well in terms of the perception of foreign audiences? Only 6% saying it's working well, 13% say it's not working at all, 32% saying it's not working too well, and 44% saying it's working somewhat. And then if you go further and ask the question of, is the US a reliable partner? 56% say somewhat, but 26% say not too well, not such a reliable partner, and only 11% saying that we are a very reliable partner. So when you add this all up, you very much get to the view that although there's a certain amount of welcome back America, we have a lot of work to do in speaking to foreign audiences to say that the US model of democracy is one that we can hold forth and say we have a values-led basis and come on board, and we are all people acting from a common standpoint. And so when you have something like I referenced in my comment on Tucker Carlson going to Hungary and saying that the illiberal model of Hungary is where we are as a country, that goes to further undermine this view that the US model is one that we can say other countries should ascribe to, and they should have confidence in our electoral
Richard,
system.
Richard, let me interject and say one of the concerns has to be that we had such a whipsaw from President Obama to President Trump, now to President Biden, that creates uncertainty about what may happen in 24. That has to be a factor, I would think.
100%. And so the question of what we do with our own voting rights standards and what is occurring in the kind of rule of law debates that we have been discussing through these series of panels is in fact what other countries are looking at. And in May of 2017, just months into the Trump administration, after he had made his first trip to NATO, where he kind of took to task our allies, Angela Merkel made a very significant comment that and I'm paraphrasing, but she essentially said, we can no longer rely on others. We now need to look to ourselves for our leadership. And what we have seen across the globe is former friends and allies triangulating their relationship to the US versus China, for example, and saying, to what extent do we need to look at our own economic relationships, security relationships, and democratic institutions in charting our own course, and the extent to which the US is a reliable partner.
You dropped off for a second, and what I want to do is, because I want to bring in Barbara in a few minutes. Barbara, thank you for your question. All of you have talked about some of the state's issues right now with voter rights and laws. So what do we need to focus on? And one of the things is, what is really going on and the difference between voter suppression laws and election subversion laws? Sort of explain, I mean, offhand I get what that is, but go in a little bit more detail about that, Rich.
The state legislatures, not all of them, but state legislators across the country have been passing laws that will be engaged in voter suppression, limiting the number of voters that will be able to participate and cast ballots, to be simple, in many ways. But there's a separate type of provision that's being passed that Rick Hazen, the excellent elections specialist, talks about: election subversion. And that is far more insidious, getting far less attention, and is far more dangerous. Election subversion, for example, allowing or saying that poll workers will be criminally liable if they get in the way of partisan poll workers in some way, that poll workers could be subjected to criminal law and thrown in jail. What's the plan there? The plan, obviously, is to chill the interest of volunteer poll workers who get paid minimal amounts to participate in elections. So who will be the poll workers? Partisans in the next elections. And that would allow, that is one election subversion technique that would allow, after the polls have closed, games to be played with the ballots themselves. And that is an enormous problem. In a Woody Guthrie sense, it's criminality that will be legal because it's passed by a legislature, but it is directly opposed to the rule of law and to what we have in our democracy.
Chuck, I'd like you to respond, but before you do, let me just mention, I said Barbara Chatterjee had a question. What she really did was reaffirm what you have said. Let me just read this. While the prosecution of President Trump is surely a key issue that requires resolution, it is not equal or more important. It is equally or more important to get legal action moving in various states that are being made to change the voting laws. And her last sentence is, we must get away from soundbite, simplistic information sharing that feeds opinion by constant reiteration. And she's grateful that we're going into detail on this. So thank you, Barbara, for joining us. Chuck?
Well, I think we have to start with the notion that our system has many partisan elements of voting regulation to begin with. In almost every state, the chief election officer is an elected partisan official. And we know how difficult and dangerous that can be, even without any of these current laws that are being passed. Think back to 2000 and Katherine Harris in Florida. Think of the recent election in Georgia when Kemp beat Stacey Abrams for governor while he was Secretary of State and had just purged the rolls and was also the one making the decisions with regard to election procedures. So we start from a partisan perspective. We don't start from an independent electoral commission or governing body perspective, which is international best practice and which occurs in many other countries, and which we can find details on, for example, from the Carter Center website. So when you start from that, and then you move instead in a direction where there is now authority in some states to replace the independent, relatively independent local election boards with a single person who is a person chosen partisanly. That is a very dangerous situation. And that's happening right now in Georgia, where they passed the law and they are challenging, they being the legislature, I guess, is challenging whether or not the Fulton County Election Commission had behaved in an appropriate manner, and are saying we're going to replace the Fulton County Election Commission with, our person who's going to go in there and tell us that what they did was incorrect. I agree with Rich that these election subversion notions are much more dangerous than the suppression of voting, which of course itself is very dangerous, and that action needs to be taken. Now, unfortunately, and maybe one of the others, maybe Rich can talk about this, I think if you parse the major legislation that's in front of Congress that's being held up because of the filibuster now, that came from the House and was passed by the House, that that issue is not so directly addressed. What's really addressed are the voter suppression issues more than the electoral subversion issues. But so it seems to me that there needs to be a federal response to this, either based upon current law or passing other laws, and that the deference that is traditional in this country to letting the states run elections, even elections where federal officers like senators and presidents are being elected, is being shown by current action to be misplaced.
What do we see anything now before the Supreme Court that could make a decision on this? Or
well, the Supreme Court, I just reread this morning the Brnovich case, which is
what is that?
That's the case out of Arizona. Mark Brnovich is the Attorney General of Arizona, and the case involved challenges by the Democratic National Committee on two things. One is so-called voter harvesting. That's the pejorative term, where somebody other than the person who actually casts the ballot collects it and puts it in the mailbox or drops it off at the polling place. And the other one is the non-counting of or the complete disregard of ballots that are cast in the wrong precinct. And by the way, in Arizona, precincts change all the time. The voting places change all the time. And there's an astonishing statistic in the dissent written by Justice Kagan in that case, that nationwide, over 90% of the votes that are invalidated because they're cast in the wrong place are from Arizona. And that fact was in the record that was determined by the Supreme Court, where the majority said, hey, there's no problem here. You know, nothing bad is going on. Let's just let the states run their elections, when there were some really astounding facts in the record. And also the other one about voting harvesting is primarily about lack of access to either mail, post office, or polling places in the Native American reservations, because a number, the record also had lots of facts in it about the fact that, you know, for many people, it's a 2-hour drive, and they don't have a car to get to the local post office in order to be able to mail in their ballots. So somebody else coming by and picking them up makes it easier for people voting. And they said, well, that's not a big deal either. That's what the majority said. So what the Supreme Court, the way it has moved recently on the Voting Rights Act, starting with Shelby County versus Holder, that said that Section 5, the pre-clearance provisions are no longer necessary because, after all, we're in a post-racist society, post-racial society, to this one in Brnovich, basically have gutted the Voting Rights Act, and there really is very little federal protection now against the kinds of things that are going on in the states.
Chuck, I'm glad that's a perfect segue. And Richard, I hope we keep you online, because this is really a question addressed to you. Are there international standards? And knowing how the U.S. usually reacts to multinational agreements and treaties, I suspect there are, and we've probably opted not to be part of it. But are there international standards? And as you reflect on that question, what about monitors that I know many of us have volunteered to be monitors in other countries? Do we have monitors coming internationally to monitor our own elections?
First, apologies if my internet blanks out, so I'll try and be very quick and efficient. The National Conference on State Legislatures has a great website which gives the standards by individual states about what they do with respect to people coming to monitor our elections. Generally, people coming here are invited by the Department of State in cooperation often with the Organization of Security and Cooperation in Europe. But as far as universal or international standards, there's a variety of international conventions. And one that I think is particularly helpful is if you look at the Declaration of Principles for International Election Observations. I'd like to read a quote from what they say, which really sets a great baseline. Quote, genuine democratic elections, it's a key concept, genuine democratic elections are an expression of sovereignty which belongs to the people of a country, the free expression of whose will provides the basis for the authority and legitimacy of government, the rights of citizens to vote and to be elected at periodic, genuine democratic elections are internationally recognized human rights. Genuine democratic elections serve to resolve peacefully the competition for political power, which within a country and thus are central to the maintenance of peace and stability. Where governments are legitimized through genuine democratic elections, the scope for non-democratic challenges to power is reduced. So this whole concept is to imbue election rights as international human rights protected by international conventions such as the Declaration of Human Rights and the International Covenant on Civil and Political Rights. Now, under international law, genuine election, that concept I referenced multiple times, is not defined, but it does have some constituent elements that kind of flow universally through. First, they should be openly competitive. They should have universal and equal suffrage, so no discrimination on the basis of, ethnicity, gender, the typical kinds of things that we want to ensure that, disability, that everybody universally has access, that the ballots are secret, and critically, as a measure, anything that undermines the will of the people will render an election unfair. And so when you look at the idea of sending out election observers, they should be nonpartisan, they should be non-political, they should ascribe to these standards that can be country specific and respecting the full sovereignty of any country to create their standards, but there are these universal measures. And these universal measures apply not just to election day, they apply to the whole process from voter education all the way through the way things are tabulated. And in the context of international observers, they come and prepare reports that then can be used as an objective measure in determining fairness in disputed elections.
Richard,
So
I may have missed this. Did you say, who do they work for? Who appoints these people?
Well, in general, they are invited in by the host country under standards that are observed by international standards, in the same way that you could look at that reference I made to the National Conference on State Legislatures that shows the individual states that present their standards. And what you can see, if you look at the many states like Texas and Florida, for example, that are engaged in legislations that are not universal voter friendly standards, they also, under their individual states, have a legislation indicating their standards for international election observers. Similarly, we have very good standards in the state of New Mexico, which even includes a provision for academics to come and look at what we do in New Mexico as part of an academic study to what our election standards should be. In the case of Florida and Texas, for example, there is very limited ability for international observers, but most states in the US would permit international observers. and other countries will have their own individual standards. So it's really state by state, and it's underneath this concept of the Universal Declaration of Human Rights and the International Covenant on Civil and Political Rights.
But in reality, Richard, this is monitoring, doing reports, but it has no teeth.
Well, clearly, if a government wants to prohibit election observers and wants to hermetically ensure that they are not subject to scrutiny, a sovereign nation can take those steps, but in so doing, they will receive international condemnation.
They can ignore what it is that the international monitors say as well. And when you say there's no teeth, that's correct. I will just note for interest that the 2016 presidential election, at the invitation of our State Department, was monitored by the Organization of American States that produced a 150-page report 2 months after the election on that. I am not, and they were invited in. I am not aware that any such invitation went out for the 2020 election from the State Department at that time. And I just want to, I see a question from Virginia here, which is similar to what I was talking about, saying, you know, Ray states changing electoral law to subvert free and fair elections and even respect the voice of the voters. That's the problem with the way the Supreme Court is interpreting the Voting Rights Act. The Voting Rights Act, the VRA, was passed for precisely those purposes. But once the pre-clearance provisions in Section 5 were taken away, and now Section 2, which is the one that says if there is an effect of discrimination, for example, then even without intent, if there's an effect of that, then it should be set aside. The Supreme Court does not interpret it that particular way. And with regard to the question of whether or not the legislatures can overrule the rights of the voters, that is something that is embedded to a certain extent in the Constitution, basically giving the legislatures the right to determine how it is that presidential electors are going to be distributed. And now at this point, 50 out of 50, 100% of the states say, well, we'll follow what the voters say, because otherwise, what's the point of voting? But that's not to say that a state could not say, well, we think we're smarter than the voters, and so our partisan legislature will make that determination. That's from the Constitution. And this is problematic throughout. You know, we all venerate the Constitution. The Constitution is full of lots of problems, you know, from the severely anti-democratic aspects of it, to the supermajorities that are required to amend it, to the high standard in order to change a government, change the executive branch, except every 4 years, as opposed to governments, you know, falling in parliamentary circumstances, if it turns out. There's just lots of things, and this is another one, which is the creation of the Electoral College and granting the rights to the states to make those determinations, a lot of which are the result of compromises to make the southern states, the slaveholding states, happy and willing to confirm and ratify the Constitution.
Well, definitely a lot more for us to talk about. And
just,
Rich, I want to hear what you have to say on this topic, and then we're going to move to lawyer regulation.
Oh, yeah. Okay, quick on the Electoral College. Absolutely correct. 50 states now say we will follow the popular vote. Should any state legislature, before the voting occurs, before any voting occurs, say we'll have the discretion to appoint electors, under Supreme Court precedent, that could prevail. That could be okay. So that's the thing to watch. Tremendous election subversion possibilities. I'll leave it at that.
Good. All right, we have just about another 10, 12 minutes. If anybody has any questions, go ahead and submit them, and we'll try to get them at the end of the program. But My goodness, gentlemen, all of you, of course, passed your bar exams, and I'm sure when you retired, you were in good standing. But we're all watching about how Rudy Giuliani has been, his license has been suspended. He's not been disbarred in New
Mhm.
York and Washington, D.C. Sidney Powell from my former state of Texas, certainly is going through some issues in some of her defense. How are lawyers, I guess the right word would be sort of judged, and how can they lose their licenses? Rich, we'll let you, since you
Okay.
at first, since you had a longer career, I guess, than Chuck, 40 plus.
Okay, and I also did serve on the Wisconsin Board of Bar Examiners for a
Okay.
while, which there were two agencies in Wisconsin. One was the disciplinary for those lawyers already admitted. Do they get disciplined? The Board of Bar Examiners looked at, oh, you want to become admitted? Wait a minute, you've got to, follow some standards, etc. Ethical violations by attorneys are regulated by each state and usually by agencies appointed by the Supreme Court of that state. So it's within the judiciary. What we're seeing recently is two things happening. Those agencies, based on complaints usually made by other attorneys or by others, non-attorneys, considering discipline or basically discipline of currently licensed attorneys within the state. And with Sidney Powell, we don't see that quite yet, although I'm sure complaints have been filed. With Rudy Giuliani, you saw a disciplinary agency move against Giuliani. They're impartial agencies set up to monitor the practice of law and assure that attorneys follow ethical standards. Normally, you're looking at, oh, the attorney missed deadlines, the attorney negligence, the attorney played around with trust funds, shouldn't have, engaged in bad behavior. Very rarely do you see attorneys disciplined because they lied to the court. And that's what's going on here.
But Rich,
People,
let me
yeah,
interject here and ask. You said they lied before the court.
yes,
Giuliani, use your word, lied when he gave that infamous presentation and press conference at the Four Seasons Landscaping Company, or when he spoke on January 6th. How is that viewed with an attorney lying before the court or lying at a press conference?
and Giuliani's transgressions were in court and out of court. You're right. That was the big out of court. And he was talking, the analysis would be he was talking as an attorney representing a client about a case that was pending before the courts. Many cases pending before the courts. He wasn't just blathering on in some opinion piece about his own personal views. He was talking as an attorney licensed to practice about cases pending. And basically the privilege, practicing law is a privilege. And I'm going to leave it at that and let it turn to Chuck if you want.
Well, yes, practice of law is a privilege, and it is granted by this patchwork, just like virtually everything else in the United States. All the states have different ways of doing this. There are 50 different systems, and there are compendia of these systems if anybody's interested. You can find them about what you need to get admitted. Is there a character and fitness standard? Is there not? Can you be admitted because you're a graduate from a state law school? Do you have to take a bar exam? Can you use the same bar exam in different states? Every state is different, but every state is fundamentally from the top regulated by the Supreme Court, and the Supreme Court sets up some kind of procedure for doing this. But because the practice of law is a privilege and you are given a license to do that, and you are called a lawyer licensed by the state, certain aspects of your behavior can be controlled greater than they might be controlled if you were just a private citizen. So you think about the implications of First Amendment. You know, can you just go out and say something about a public figure that is wrong? Yes, you can, generally speaking, and you won't, generally speaking, be subject to any kind of defamation suit. However, if you are practicing law and you are talking out of court about a case that is pending in court, as Rich said, then there are very specific rules, and you can, in fact, be disciplined on that. You can also be disciplined by courts who have cases, by the judge who is hearing the case, if you make outlandish, untrue statements that are made for an improper purpose, made without any factual basis, or made without any basis in existing law. And this, you remember, Sidney Powell's defense of the Dominion voting defamation lawsuit was, no reasonable person would believe that anything that she said in this lawsuit was true. Obviously, it was not factual. Well, I mean, that's in effect saying that, as we lawyers say, Rule 11 has been violated. Now, what's the reality? The reality is that it's very unusual for any kind of meaningful, other than some kind of a monetary sanction, to be applied by a judge in a lawsuit under Rule 11 or any other rule of procedure. It just doesn't happen that often. And it's also very unusual for lawyers to be disciplined for other things, for things other than taking money out of a client's trust account, or missing deadlines, or committing some kind of heinous felony, or just doing that kind of thing, as opposed to how the lawyer behaves, the lawyer's conduct in a court proceeding or out of court proceeding.
Chuck,
so there's all these rules that are not really applied, I think, effectively, but they exist.
Richard, let me ask you this, and if you could respond briefly. If an attorney loses his license, disbarred in New York, can he still practice in other states, or how is that notice of disbarment made known throughout the country, and does it make any difference?
Well, essentially a different bar association. So if you look at the case of Giuliani, just as a for instance, he was disciplined primarily in terms of his license suspension in New York, but then he's also licensed in DC. So the DC authorities looked by reference to what New York had done, and then they decided to do a suspension in their jurisdiction as well. So when one is disciplined in one place and they're licensed in another, the information is communicated to the other jurisdiction where they're licensed, and then that jurisdiction will determine whether to take a similar action.
And also, Jim, when something happens in court, one of the remedies that a judge has, if a lawyer behaves badly or violates some ethical rule, is to make a reference to the disciplinary, the relevant disciplinary authority from which that lawyer has received his or her license.
And let me say, when an agency gets a message like that from a judge, it's taken seriously.
Aren't we lucky to have the three of you working with us? So thank you very much for being our guest. So thanks again for being with us, and we'll see you next time here on our channel. Take care. Bye-bye.